In this video, we take a look at the latest XRP news. Will XRP be able to fly to the moon? Write answers in the comments. Notably, Replex reported that the XRP's 39 clawbacks functionality, which is scheduled to launch on the XRP, is now up for vote. Ripple to David Schwartz got forward to give his opinions after the news was met with skepticism from community members. Schwartz has attempted to ease concerns about this new function. He began by explaining that the clawback functionality would allow token issuers to recover a particular number of issued tokens from existing holders. He said that he was originally opposed to the functionality since the XRP already had the freeze feature, which is identical to clawback. However, he said that the obvious contrast between clawback and the frozen function caused him to reconsider. Schwartz emphasized in his comparison that the clawback function would find a main use case in legal disputes. He feels that the opportunity to recoup some cash in the event of a disagreement relieves the token issuer of the legal responsibility. This protection, according to Schwartz, is crucial for complying with court orders. He feels that auditing protocols on the XRP will be challenging with the existing model without the clawback capability. As contrast to freeze, which is a more nuclear option, the Ripple key to define the capability as a tool that enables for surgical strikes to preserve the XRP intact. Overall, Schwartz said that this new capability is presently available in blockchains that house stablecoins. He pointed out that if the proposal fails to pass, token issuers would have to go to the trouble of activating the functionality in some manner. Other major players in the XRP ecosystem, including Azrathoth Gneeman, Woke, have also worked to debunk falsehoods concerning the clawback function. According to him, there is no hidden adjustment in the XRP ledger ecosystem. With the issues addressed, the clawback functionality will be implemented if 80 of existing validators vote in favor of the proposal. For the proposal to fly, the minimum threshold must also be maintained for at least 2 weeks. The XRP has undergone a considerable revision in recent months, with a number of changes suggested. The team behind the XUM wallet recommended a revamp of the XRP infrastructure to incentivize participation via incentives, as previously reported by the crypto basic. Spend the Bits, a payment protocol on the XRP, won the top position in the Ripple CBDC Innovate Award, a display of the ledger's exemplary work, recognizing the efforts of the core developers internationally. On 6 October 2023, John Reed Stark, a regulatory compliance specialist in the digital arena with a 15-year stint as an cease enforcement attorney, turned to social media platform X, previously known as Twitter, to offer his thoughts on Judge Torres' recent ruling regarding the SEX index. Stark underlined that the judge's decision to dismiss the SEX's interlocutory appeal also indicated that her earlier summary judgment should not be regarded as establishing a legal precedent unless the circumstances of a new case are similar. Stark pointed out that, although this may seem to be a little success for the XRP team, it might ultimately be a hollow victory. He expects the SEC will appeal the verdict after the trial and has a decent chance of prevailing. Judge Torres clearly said that her judgment is not to be regarded a precedent for subsequent instances in the Bitcoin industry, according to Stark. Stark also praised John Deaton and the XRP team for standing up to the SEC's unilateral law-making techniques. He stated his displeasure with attorneys who switch between law firms and the SEC, implying that such attorneys are unlikely to question the status quo owing to possible conflicts of interest. Stark commended Deaton's team for exposing the SEC's unappreciated work in addressing less publicized but critical matters such as microcap fraud and penny stock fraud. Stark, on the other hand, was emphatic in noting that Judge Torres' Ripple ruling should not be referenced as a precedent on whether tokens are securities. He emphasized the judge's unequivocal statements that her judgments were based on the Ripple case's unique facts and circumstances. Judge Torres rejected the SEC's assertion that the issues posed in the case are crucial legal issues with far-reaching repercussions for several other cases in his judgment, denying the SEC's motion for interlocutory appeal. She stressed that her judgments are based on applying the Howey test to the facts and circumstances relevant to this Ripple instance. Judge Torres went on to add that the SEC's citations to other enforcement cases involving other digital assets and firms are not directly comparable owing to differences in facts and economic circumstances. She further clarified the SEC's interpretation of her findings, indicating that her order should not be seen as establishing a precedent for future digital asset disputes. The SEC had specifically tried to determine whether an issuer's activity on cryptocurrency trading platforms may provide investors with a reasonable expectation of profit. Judge Torres explained that her decision was based on the whole set of facts and economic reality underlying Ripple's programmatic sales rather than a blanket pronouncement on the subject. Any lawyer who uses this ruling as a general rule on token regulation risks ethical ramifications for breaching their duty of transparency, according to Stark. This is because Judge Torres has said unequivocally that her ruling has no precedential weight, save in very limited cases when the facts are similar. Stark continued by warning that referencing Court Torres' ruling in a larger context would be an ethical breach, since the court has explicitly declared that her decision should not be seen as having universal validity. The current triumph is unquestionably a last nail in the coffin. The issue is whether the SEC will abandon the complaint or seek a settlement with Ripple. The court's decision to deny the SEC's appeal confirms an earlier determination that secondary XRP sales are not securities transactions. This demonstrates that Ripple's conduct in selling XRP tokens are not in violation of securities legislation. The judgment of Judge Annalisa Torres dealt a blow to the SEC's legal approach and exposed several significant flaws in its reasoning. The SEC's approach was predicated on the notion that some XRP sales might lead to investors anticipating rewards based on Ripple's efforts. However, the court deemed this argument to be devoid of relevant evidence, confirming the prior decision. Ripple's CAO, Brad Garlinghouse, didn't miss the chance to remark on this recent event in his ex-post after Deaton. He humorously observed that the C, in its pursuit of applying the Howey test in the case, eventually lost. He mocks the SEC's own creation of this criteria, based on which they were slammed in court. They seem to want an exceptional lawyer to comprehend the significance of their own made-up securities legislation. Looking forward, the SEC is now in a position where it must await additional findings in the wider Ripple action before considering any appeal. The next central hearing is scheduled on April 23, 2024. However, both parties must file pretrial materials by December 4, 2023. According to Jeremy Hogan, the matter will either go to trial or be dropped in April. Furthermore, this judgment enhances the judge's prior ruling, making it more difficult for the SEC to prevail in any prospective appeal. As the current tide is moving towards Ripple and Coinbase, the SEC may be in a stronger position if they act in their best interest to introduce clear crypto legislation. The SEC is facing a critical decision. In a recent discovery, digital asset researcher Anders revealed why the U.S. Securities and Exchange Commission, SEC, chose to pursue Ripple and XRP. The Securities and Exchange Commission's allegations against Ripple in December 2020, citing the sale of XRP as an unregistered securities offering, sparked discussion in the crypto world, especially among XRP fans. Deaton presented a range of thought, provoking questions in his thread about the SEC's special targeting of XRP. He questioned why the SEC would choose a more difficult case, drawing parallels to the early sales of ETH when the Ethereum team launched a simple initial coin offering ICO. Anders points out that the SEC's determination to target XRP is motivated by Ripple's creative use of the digital asset in cross-border settlements. Ripple's use of XRP, according to Anders, undermines the conventional nostro-vostro accounts and banking paradigm, which has long been a substantial income source for many big banks. According to the study, this disruption threatens to expose established financial institutions' lack of innovation. It is critical to understand that Ripple Labs' primary goal is to revolutionize blockchain payments, with XRP playing a key role. Ripple removes middlemen in cross-border settlements, reducing delays and excessive transaction fees.